home of the longest-serving and arguably most influential Supreme Court Chief Justice, John Marshall. My name is Mika, and I'm the Education Manager here, and today we're going to talk about Marshall's most important Supreme Court case, Marbury v. Madison of 1803. Back in 1789, when the U.S. Constitution created the Supreme Court, it did not likewise identify what the court could and could not do. It was Marshall, during his 34 years on the court, through court cases like Marbury v. Madison, that he established the court's powers and authorities. The minute details of the Supreme Court case, Marbury v. Madison, matter less than the actual ruling that Marshall made in 1803. At the end of this court case, he determined the concept of judicial review, which essentially established that the Supreme Court has the power to interpret and enforce the U.S. Constitution and determine laws unconstitutional, an authority that previously lay with Congress. The concept of judicial review is such an important one that has come to create our modern judicial system, and we see it play out over the course of the decades since 1803 and across court cases to our present day. But how did we get to this concept that the court has the power to enforce the Constitution and determine laws unconstitutional? Well, back in 1800, when President Adams saw an end to his first and only term as President of the United States, we see a transfer of power in the election of 1800. Thomas Jefferson comes to the presidency with a states' right ideology versus President Adams' Federalist ideology, which offered and supported a strong national government. This transfer of power is incredibly important because it was peaceful, and this in itself comes to impact our elections since then. At this time, U.S. presidents were inaugurated in March and not January as we see them now, mainly because with poor travel, poor roads, and poor weather, it was difficult for people to get to Washington, D.C. in January, and so presidents were sworn in March when it was easier to get around. As such, President Adams would have been president until March 4th, 1801, when Jefferson became president on that midnight. At the end of Adams's term, there are 34 federal judge and justice of the peace positions to fill across courts in the country. And Adams wants to fill all of these posts with Federalist judges who will be loyal to the Federalist ideology of supporting a strong national government. Adams uses the very last minutes and, in fact, seconds of his administration to fill these court positions just before Jefferson becomes president on midnight, March 4th, 1801. Naturally, Jefferson would want to put his own men in these judge positions, but it's Adams who is just sort of trying to connive and get in Federalist judges before the clock strikes midnight. As the court case Marbury v. Madison will determine years later, President Adams is following all of the correct steps to get these 34 men appointed to their federal judge positions. First, he gets the Senate to confirm all of their appointments, and then he begins the process of having the Secretary of State deliver these commissions or letters of employment to all of these men. However, Adams has to have the Secretary of State deliver all of these letters before midnight on March 4th, 1801, and all but 4 are delivered successfully. Those remaining 4 letters of commission roll over onto the new administration, which is, of course, President Jefferson, and with him a new Secretary of State, James Madison. Now, Madison and Jefferson do not want to confirm these final 4 appointments, and yet these 4 men, of course, want to see their commissions go through. One of these belonged to William Marbury, who is quite upset that James Madison does not want to approve his appointment. Madison argues that because the appointment was not delivered before midnight, that it is void and will not go through. But Marbury, in fact, takes an appeal directly to John Marshall on the Supreme Court and asks Marshall to essentially force Madison to approve this commission. This is when we see the important establishment of judicial review. It's during these early stages of the court case. Marshall hears Marbury's appeal and says, Yes, I have the power to do as you ask, sir. I can force Madison to approve your commission. But in fact, in my reading of the Constitution, and more specifically, the Judicial Act of 1789, I determined that you do not have the authority to ask me directly to appeal to Madison. In fact, it seemed, and it was, that Marbury essentially skipped the order of appeal. It skipped steps by going directly to the Supreme Court to appeal this commission. He should have gone through smaller courts first before going to Marshall. And it's this technicality, this act in itself, that establishes judicial review. So it doesn't matter so much about Marbury's commission or President Adams' and his appointments. It matters that Marbury skipped all of these steps. And so Marshall determines that, yes, I have the power to do as you ask. I have the power to tell Madison to make you a judge, but I'm not going to, because I determined that your asking me was unconstitutional, that you skipped all these steps, and so I am determining and I am interpreting the Constitution as I see it, and I do not want to send that letter to Madison as you have requested. So ultimately, Chief Justice John Marshall did not tell Madison to approve Marbury's commission. And at the end of the day, this doesn't matter. It was Marshall's solitary act of saying, yes, I can, but I won't, which created judicial review and gave him the power, or rather, he gave himself the power to determine a law unconstitutional. So judicial review, again, begins in 1803, and it becomes the foundation of our judicial system here in the U.S., and we see it play a part in cases since this time. I hope this video of Marbury v. Madison has been helpful in breaking down the details of the case, but also identifying the most important part, which is, of course, the idea of judicial review. If you liked this video, please let us know. If you want more videos, please let us know. And please have your teacher or your parent look for the attached resource packet to this video, which includes a lesson plan and primary source activities and little cartoons for you to help solidify the idea of judicial review. If you want to come visit us at the Marshall House, we're open for public touring Friday to Sunday in closed groups and by appointment during the week. Thank you.